as the master of ceremony to this noon that we conduct the event, the 4th International Public Lecture. I am Muhammad Baharul Ulum, a lecturer at the University of Jember Faculty of Law. I'm delighted to welcome our speaker this noon, Azzuddin Al-Mahjoub, PhD from Qatar University, and our moderator, Dr. Al-Hanif, PhD from University of Jember Faculty of Law. And our Dean, Dr. Bayu Dwi Anggono from University of Jember Faculty of Law, and Vice Dean, Dr. I. Gede Widyana Swada, and all the participants to this virtual meeting, International Public Lecture, the 4th International Public Lecture, Transformative Visions of Islamic Jurisprudence. Before we start this meeting, let us honor this event with Indonesia's national anthem, Indonesia Raya, and followed by hymn UNED. Then we turn to the welcoming remarks by our Dean. We would like to request the Dean to open this event officially.
Yeah, thank you, Pak Barul Ulum. Assalamualaikum warahmatullahi wabarakatuh, and good afternoon. The Honorables, Ezieddin El-Mahju PhD, Associate Professor from Qatar University as a speaker. Igede Wediana Suwarda PhD, Vice Dean of Faculty of Law, University of Jember. Al-Khanif PhD, Lecturer at Constitutional Law Department, Faculty of Law, University of Jember, as a moderator. And all committee and participant of the International Public Lecture. As the Dean of the Faculty of Law, University of Jember, I am pleased to meet Ezieddin El-Mahju PhD and welcome all the participants of this International Public Lecture, titled Transformative Vision of Islamic Jurisprudence, organized by the Faculty of Law, University of Jember. For your information, this International Public Lecture has been regularly held by Faculty of Law, University of Jember since the end of last year in purpose of improving academic quality and the quality of graduate for both undergraduate and postgraduate program. And this event is the 4th International Public Lecture that we have held. To inform Ezieddin El-Mahju, the University of Jember is a public university in East Java province with 15 faculties and approximately 40,000 students, where 3,000 them are from the Faculty of Law. University of Jember is ranked 10 of the best university in Indonesia according to 2021 Webometric rank of university. Speaking for myself, the topic of this public lecture is quite interesting because Indonesia is a country with the largest Muslim population in the world, in total of 229 million people, which is 87% of the total population of Indonesia. We know that Islam, from the very beginning, comes to this earth with transformative vision. It's not only bring change in Aqidah, from ignorance to Islam, but also make social change from unjust, cruel, and arbitrary society to society that is just, peaceful, and respectful society toward differences. This can be seen from history with the Medina Charter, which contain a statement that the Muslim and non-Muslim in Yathrib or Medina were one nation, and Jews and Christians as well as other non-Muslim will be protected from all types of blasphemy and harassment. Even in the Medina Charter, which was declared by the Prophet Muhammad SAW, peace be upon him, there were 47 articles that regulated the political system, security, religious freedom, and equality before the law, peace and defense. Islamic law is one of the sources of material law for development of national law in Indonesia and has received a constitutional basis. This is because the teaching of Islam are a way of life, moral ideal and legal ideal for the majority of Indonesian people who are Muslim and have an important role in the establishment of the fundamental norm of Pancasila, 5 principal state. Another reason is that the development of legal history in Indonesia so that the legal ideal and the existence of law based of Islamic teaching have a continuous level of actuality. Before closing this speech, I would like to say many thanks to Ezieddin El-Mahju PhD, who has been willing to be a resource person, and the committee who have prepared this event. Finally, by saying Bismillahirrahmanirrahim, I officially open this international webinar or international public lecture. Thank you to the committee and participants. Wassalamualaikum warahmatullahi wabarakatuh. Good afternoon, stay healthy.
Thank you, Mr. Dean, for the speech and opening this event. And the last is prayer by Mr. Fiska Mauludian Nugroho. Halo, Mr. Fiska.
Ya, halo. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, Mr. Ezidin El Masjud, Mr. Dean, Bayu Dwi Anggono, Dr. Bayu Dwi Anggono, and my lecturer, Ike Dewi Diana Swarda PhD, and moderator, Mr. Al-Hanif PhD. Good morning, salam sejahtera. Good afternoon, salam sejahtera, shalom, om swastiastu, namo buddhaya, and salam kebajikan. Allow me this noon to lead the prayer procession. Prayers offered will use Islamic prayers, and participants of other religions are welcome to use prayer procession according to their respective faiths. Prayers begins. A'udzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Wal aqibatu lil muttaqin wa la udwana illa 'alal zalimin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajmain. Ya Allah, ya Allah, ya Allah, ya Razzaq, ya Rahman, ya Rahim. Rabbana ظلمنا أنفسنا وإن لم تغفر لنا وترحمنا لنكونن من الخاسرين ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين. Alhamdulillah Rabbil Alamin. Thank you for all. Thank you for participant. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you, Mr. Fiska, for the prayer session. And I think this opening ceremony has been finished, and we are now continuing to the next agenda, the discussion. And the discussion will consist of presentation and discussion. And in this discussion session will be chaired by Dr. Al-Hanif as the moderator. And I want to call Mr. Hanif. Hello, Mr. Hanif.
Hello, good afternoon.
Okay, I will forward to you to handle this event as the moderator.
Okay, thank you very much, Mas Arul. Welcome, Dr. Izzuddin El Masjub. Good afternoon. What time is it now there? Okay, it is not too early, yeah?
Yeah, that's not too early. It's okay. Thank you.
Okay, thank you very much for the coming. My Dean, Dr. Bayu, Vice Dean, Dr. Gede, all participants, my colleagues in Faculty of Law. It is very good to have Dr. Izzuddin El Masjub because, to be honest, that Indonesia, even though it is the largest Muslim country in the world, but the discussion on Islamic law in we call it secular Faculty of Law is very rare because in Indonesia we have two different kind of universities. One is associated with the Islamic, the Ministry of Religious Affairs, and then University of Jember is associated with the Ministry of Education. So yeah, thank you very much for the coming and for the time, Dr. Is. How should I call you, Dr. Is?
Whatever works best for you. I mean, my full name is Azdi, and I don't.
Okay,
that's fine. But Ez is good as well.
Okay, thank you very much, Dr. Ich. Before we are going to start our discussion, so let me introduce yourself to all participants, because I do believe that it is only Mas Gede, Mas Jade, who met you before. So yeah. I have to introduce you to everyone. So let me read your CVs. So Dr. Izzuddin El-Majub is now currently acting as the research. Wait a second. In Qatar University as a lecturer and associate professor. And Dr. Eads graduated from Queensland University of Technology. Perhaps you were the good friend of Master
Definitely.
Yeah, he's my best friend, one of my best friends.
Yeah, this is how usually our networking built based on the personal networking. Yeah. So Dr. Eads will discuss and let me wait a second. Oh, I have a technical problem. Okay, Dr. Eads will discuss and deliver a topic. This is very heavy. I do believe that it is very heavy, but it is also provocative theme of the seminar, Transformative Vision of Islamic Jurisprudence towards an Islamic legal philosophy. So as we perhaps some of us know that Islamic law has been developing, but in some areas is decreasing and some other areas is increasing. For example, like Islamic international law was established in the early phase of Islam is very powerful until in the Middle Age, but now it is decreasing because of the establishment of international law. But in some other areas, Islamic law is increasing. For example, in Indonesia, we have one province in Indonesia which implement Sharia law. Perhaps if Masjid is going to invite you to come here to Jember, so you must visit Aceh province on the tip of Sumatra. So it is the only province in Indonesia which implements Sharia law. But of course, perhaps it is a bit different, or maybe I don't know. My focus is not on Islamic law. Perhaps you can share with us about the realities of Islamic law in other countries, maybe in Qatar, maybe in your home countries, or perhaps in some other university, some other countries. So our participant will know like a broad ideas about the transformative vision of Islamic legal jurisprudence. So without further ado, I give you 30 minutes, and then after that we will have a Q&A. Time is yours, Dr. Eads.
Yeah, thank you very much, Dr. Hanif, for this introduction. I wonder if I can get the slides, Jade. Can I get them shared?
Yes, you can share your screen by yourself.
Yeah.
If you don't mind, you can share it by yourself.
Yeah, I'll try to find it. I don't normally use Zoom. So share screen. Okay. Okay. All right. Okay. Now, can you see the PowerPoint slides?
Yes. Yes.
Yep.
Yeah. Perfect. Okay. First of all, thank you very much for this opportunity. I am very, very grateful for Faculty of Law, Jember University. I'd like to thank the Dean, Dr. Bayo, and his deputy, and Dr. Al-Hanif for this introduction, and the Vice Dean and Dr. Bahr Al-Ulum for participating in this event. I particularly would like to send special thanks to my friend and colleague, Dr. Jade, for arranging this seminar presentation for me. Okay, so now today I'll be talking about a transformative vision of Islamic jurisprudence towards an Islamic legal philosophy. I have this presentation outlined just to put things into perspective. So as I mentioned, I'll be talking about how we transform our perspective on Islamic jurisprudence, particularly legal reasoning within Islamic jurisprudence. So I'll start by explaining what do I mean by the proposed vision, transformative vision of Islamic jurisprudence. I will talk about how legal philosophy is perceived in Islamic legal discourse, and I'll explain then the scope of legal philosophy within Islamic jurisprudence. And then I'll talk about how the idea of legal philosophy developed in Islamic jurisprudence. Okay. Now, a spoiler alert. I mean by transformative vision of Islamic jurisprudence, the process of reintroducing Islamic legal and jurisprudential discourse into some form of normative philosophy that tells us about the right thing to do. Now I'm doing this to find a way to inform the process of lawmaking in modern state. As you might all know, particularly those interested in legal philosophy, what does legal philosophy exactly do is to define general standards for right and wrong in legal context. It tells us that this law is good and this law is not good. So for example, legal philosophy is the branch of law that will help us understand why freedom of religion is good, okay? And why private property, for instance, should be protected and how should we protect it. This is the task of legal philosophy. Now, when I say transformative vision of Islamic jurisprudence, I don't mean completely new vision, yeah? And I also don't intend, obviously, to undermine the importance of Islamic jurisprudence. I'm not saying that we should delete the existing classic Islamic jurisprudence. What I propose is a new methodology to understand and develop the content of Islamic legal philosophy based on both classic and modern Islamic jurisprudence. This is why I titled the presentation Transformative, not entirely new vision of Islamic jurisprudence. Now, legal philosophy in Islamic legal discourse. The first question that I wanted to ask myself, is there a general legal philosophy in Islamic legal discourse? Does Islamic jurisprudence know legal philosophy? First of all, the mainstream discourse from Islamic jurisprudence itself and about Islamic jurisprudence depicts Islamic philosophical contribution to lawmaking in a positivist sense. What do I mean by positivist sense? When you read Islamic jurisprudence, classic or modern, you find jurists talking about haram, specific haram, and halal, allowed and prohibited. This is the kind of reasoning. There are no general normative standards being the main focus of Islamic jurisprudence. Now, the positivist vision means that for some people, or the mainstream, I should say, the rules of Islamic law are taught to be known, rigid, and have specific source and codes. Now, according to this narrative, the rule derive their authority and validity from the fact that they have been posited. This is the source of the word positivist. Posited, meaning decided, established, ordered, prohibited, or permitted by Islamic scripture and Islamic classic discourse. Now, thus a positivist Islamic law is thought to have internal logic of itself, about textual imperative detached from social context, from merit consideration, from big issues like human rights, like justice, like fairness, like economic efficiency. If you talk to jurists, they will just focus on applying specific text, whether from the Quran, Sunnah, or from other sources, to a specific context, like, for example, marriage, divorce, hudud, corporeal punishment, etc. Now, what I'm trying to do here is to say that there is another way to understand Islamic jurisprudence as a source for legal philosophy. But before I do this, I want to let you know why do we need to discuss an Islamic legal philosophy, why this is important. I believe that we need general normative principles rooted in Islamic worldview to tell us when and how, in the Islamic worldview, a law can be said, a general law in modern states, can be said to be good law or bad law, efficient law or inefficient law. This thing is important, as I mentioned, because modern political, social, and economic systems are complex. These systems developed over centuries, and this development, particularly in this centuries, is fueled by unprecedented technological advancements. As a result of this, I believe classic jurisprudential methodologies should also evolve into some form of general normative standards. What I mean by normative standards is basically a philosophy of law to tell us how this classic old Islamic jurisprudence can be used to say that this law is good or bad. The second reason, liberal thinkers, secular thinkers, have for a very long time rejected and challenged all religious, perhaps especially Islamic, contributions from the discussions about lawmaking in modern political and legal systems. Now, the most moderate ones, those open-minded scholars, for example, like the American philosopher John Rawls or the German philosopher Jürgen Habermas, they requested that religious contribution to political and legal discourses shouldn't come in the form of jurisprudence, shouldn't come in the form of religious arguments. They said that the arguments must be presented in reasonable philosophical vision, using terms, using concepts that non-Muslims, non-religious secular citizens can understand. So those scholars, among many others, rejected purely metaphysical religious arguments. Now, I believe transforming Islamic jurisprudence into philosophical discourse will help. For if we assume that if we assume that religious contributions can only take the form of metaphysically formulated statements that rely on scripture, whether the Quran or Sunnah, to engage liberal politics, then we will miss the point. Religious arguments are far more sophisticated than this perspective. For example, I give you a specific example to make these things a bit clearer. A Muslim citizen would still be acting within Islamic precepts, Islamic morality, if he or she said the following statement, a statement that would be understandable to a secular non-Muslim citizen. For example, I believe in Allah, and the primary source of truth is the Quran and Sunnah, the scripture, okay? And I understand that the scripture is not the only source for normative insights. There are unlimited normative signals underlying many narratives, commands, and prohibitions in the scripture. Those signals can be translated into some form of legal philosophy. A specific example where perhaps will further clarify my point. So when I say that we should not legalize abortion, torture, or euthanasia, the so-called mercy killing, I am not necessarily, as a Muslim, discussing this with non-Muslims, saying that Allah in the Quran says this, so we shouldn't do it, because the non-Muslim citizen will not accept this argument because he doesn't believe in Allah altogether, or because he is not a Muslim. But I can use philosophical language based on the Quran to make my point. Instead, I can say I'm drawing on the normative language from the Quran that strongly upholds the intrinsic value of human life and the inherent dignity of a human being, to say that abortion, torture, or euthanasia are morally wrong. So even if non-Muslim is still unconvinced because he prefers utilitarian argument, for example, utilitarian secular argument, he can still understand my point. So transforming the narrative from just using sacred textual sources to using philosophical arguments that find their base in the scripture. Now, what do I mean by an Islamic legal philosophy? How should we understand this? How should we start the discussion about Islamic legal philosophy? Islamic sources of legal rules, as you might know, essentially stem from the Quran and the teaching of the Prophet known as Sunnah, along with other sources like Qiyas, Ijma, and so on for those know more about Islamic jurisprudence. Both of these main sources, the Quran and Sunnah, represent a medium of positive law, specific rules, and broad philosophical positions and standards. Now, the sphere of specific positivist rules is thought to be extremely limited. Some scholars contend that there are roughly 500 verses in the Quran that send specific instructions. The late Professor Fazlur Rahman argues that the number of specific rules is even fewer. He said that there are just 80 out of 6,200 verses in the Quran that talk about, for example, numbers, like, for example, the waiting period for divorced women, inheritance, corporeal punishment like hudud, and so on. So he said that the scope of specific instruction, injunction, is limited, and the bulk of the Quran, the overwhelming majority of the Quran, the textual sources, talk about general normative standards, as I will explain in this slide. So we have in the Islamic jurisprudence discourse what the so-called posttextual normativity. What do I mean by this? Since the early period of Islamic legal development, the companion of the Prophet, just a few years after the Prophet died, maybe a few months after the Prophet died, the companions of the Prophet had to recognize that the text cannot be, the Quranic text cannot be expected to provide detailed solution for daily matters they face, especially after the Islam expanded to include different people from different geographical locations and different cultures to Arabs, where the Islam first emerged. So they started a process of searching for hikmah, underlying design principle, normative principles in the Quran. Yeah. So in this stage, the right thing to do, the behavioral instruction, do this or don't do it, did not stem directly from the Quran, but based on some kind of philosophical reading of the Quran. What the text of the Quran would do in particular situation. So, for example, they had an issue about whether the grandson of a deceased person should get a share of the inheritance. So they taught philosophically, so to speak, to use modern terms. They said that the hikmah of the Quran is to give shares to those grandchildren that their father died before their grandfather. So they assigned shares for the grandchildren, and they used the methodology of ijma to do this. So they searched for normative signal. What should we do? The text, the Quran doesn't give us specific rule. The Quran says, give the son, give the daughter, give the mother, give the father, but it didn't say anything about the grandchildren when their father passes away before them and their grandparents still alive. So when their grandparents die, should they get a share of the property or not? And this kind of philosophical reasoning witnessed a paradigm shift, a strong shift after the period of the Sahaba. So the most significant development in the post-scriptural normativity came when the jurists, the Muslim jurists, started to look and search for more flexible and overarching legal philosophy for Islamic legal norms. This particular development came through introducing the concept of maslaha. The concept of maslaha in Islamic jurisprudence. This is the consideration of public interest. I understand public interest, those specialized in public law work a lot with this concept. What would public interest say? But the public interest I'll be talking about here is theological one, metaphysical one, used to define the legal rules that we should use when the Quran and Sunnah do not provide specific instructions. Now, the concept of maslaha is generally translated as public interest, but believe me, this is more sophisticated than this, way sophisticated. It basically talks about the divine will. What Allah Azza wa Jal, what God wants a Muslim ruler, a Muslim jurist to do in a particular situation of legal uncertainty. Now, under the concept of maslaha, the focus extended beyond, the specific questions of halal and haram to search halal and haram, obviously, found in a specific text, to search for an overarching legal philosophy, to create a nexus between hikmah that we can search, wisdom that we can find in the text, and the political, social, and developing economic context in modern state. Now, Imam al-Juwayni died in 1085, and Imam Abu Hamid al-Ghazali, in their seminal work, talked about this concept, the concept of maslaha, through their search of maqasid al-sharia. Maqasid al-sharia literally translated as the objectives of Islamic law. Now, in my research in this paper, and paper published recently in Oxford Journal of Law and Religion, I take maqasid as the essence and historical source of Islamic legal philosophy. Now, this branch, the branch of maqasid, is beset by assumption that societies undergo a process of constant social, economic, and cultural changes. Muslim mindset must also operate with the assumption that these textual Muslim mindset must operate with the assumption that there is a textual answer for some things, but there will be no textual answer in the Quran for many things. So basically, maqasid al-sharia empowers jurists to approach the Quran and Sunnah with a specific purpose in mind. They analyze the text to construct underlying design principle, the design principle under the textual verses in the Quran and Sunnah. The purpose of this analysis is called inductive survey, or istiqra in Arabic, is to discover masalih, is to discover the interests that Allah wants us to protect in this world. So, for example, Al-Ghazali said that there are several, verses in the Quran that says we need to protect religion, we need to protect property, we need to protect human life. Now, in any philosophical discussion, we should always focus on these issues. Obviously, this was 1,000 years ago. The scope of wisdom, the scope of hikmah and interest in the text developed even more. Now, let me explain more, because this is really important in my transformative vision of Islamic jurisprudence, to discover the legal philosophy in maqasid. A jurist would identify, as I mentioned, underlying design principle from the text through inductive survey or istiqra. A jurist who performs istiqra will scan the text of the Quran, textual authority of the Quran, to discover the maslaha, to discover the interest. For instance, since the 11th century, Scholars like Al-Ghazali, Al-Juwayni, Al-Izz ibn Abd al-Salam, Al-Shatibi, among many others, they said that if we carefully read the Quran, we will see that there are, general normative standards, general legal philosophical norms that persistent throughout the Quran. The promotion of justice, the fight against injustice, the freedom of religion, freedom from slavery. These, general precepts that tells us that there are certain norms, certain normative signals, certain philosophies in Islamic legal discourse. Now, I tell you one example. The Quran was revealed in the 7th century, around 14 centuries ago. Yeah. And the Quran, for example, says that no compulsion in religion, that you cannot force other people to be Muslims using the sword. This is direct statement in the Quran. Now, Islamic legal philosophy will stop and ask this question: why on earth, in that Arabian desert, at that time, where people were fighting and killing each other for far simpler reason, the Quran will come for primitive society that did not develop in comparison to Rome or Persia, and say this and say that no comparison in religion. It means that in the Islamic vision, freedom of religion is extremely important. And now we should uphold this value as well in modern state, because in modern state as well, particularly plural states, this value is important. I give you another example: the right of women. The Quran in the same period, 7th century, in the Arabian desert, undeveloped society, undeveloped Arab society, comes and say women has share and men has share in the wealth when the person died. That's equality. Why on earth, again, the same question, at that time the Quran would say this? Now, when you think about this, this means that concepts of equality are important in the Quran. This should be like a general normative standard when we decide right and wrong in the Islamic worldview. Now, maslaha is the essence of doing this, because the Quran, when protected freedom of religion, is safeguarding a maslaha. It's our task to discover this, to use our reason, the gift that God gave us, that's the intellect, to understand why the Quran, the text, is trying to enforce this, this view. Now, maslaha, the concept of maslaha became the backbone, the vocal point, the most essential point in Islamic legal philosophy. The prevailing trend, the scholars, since the 10th century, they have been saying that the purpose of God's law, the purpose of the scripture, the purpose of legal reasoning in Islam, to promote the social, political, economic, and religious interests of people in general. Specifically, Al-Juwayni, who died, as I mentioned, 1,000 years ago, said that maslaha is an expression of people's well-being that results from the implementation of God's law. So in one sense, he coined this term, and 7 centuries later, up until the 16th century, scholars wrote a lot about this as the standard for Islamic legal reasoning. Al-Ghazali came in Al-Mustasfa. Al-Ghazali was the student of Al-Juwayni. He came and said that the notion of maslaha is persisted throughout the Quran, and this is why he was the first to create a taxonomy of maslaha. He said that we have 5 masalih in the Quran, and then people added to them: religion, protection of religion, life, intellect, honor or progeny, and wealth. In other words, it's assumed that revelatory commands, instructions, and narratives are linked to underlying design principle or hikmah every time we talk about philosophy. Now, let me use modern tools, modern philosophies to explain what do I mean by Islamic legal philosophy, the nature of Islamic legal philosophy. In modern legal philosophy, secular legal philosophy, there are two general comparative theories to explain maslaha or to explain interest, to use the secular term. There is the deontological concept and the utilitarian concept. Deontological concept says that when we do legal reasoning, we should always focus on a duty to safeguard that interest. Utilitarian concepts, they say that we should maximize the greatest good for the greatest number of people. Now I understand that this is a abstract philosophy. Let me give you a specific example to explain what I mean. Let us imagine that a utilitarian and deontologist are debating whether we should mercy kill somebody. Euthanasia, somebody is terribly sick, and can we use lethal injection to kill him or kill her? A deontologist would say, no, we shouldn't do this. A human life has an intrinsic value, and the law should always uphold the duty to protect the sanctity of life. Utilitarian would say, no, we shouldn't do this. What we should do is to look if this person is suffering pain, calculate the consequences. Will this person suffer pain? Will be wasting health resources, economic resources if he stays alive, and we choose the course of action, the legal rule that would maximize the benefit, meaning save money or probably prevent more pain being inflicted on this person. Now, what is the nature of interest in Islamic legal philosophy? How should we understand it? Now, the problem is that the nature of philosophical interest in Islamic legal philosophy is extremely vague, mainly because this is a new question. Former jurists and scholars, they didn't focus on reading maslaha, on reading public interest in Islamic law or Islamic philosophy using modern philosophical tools. Yeah. Now, should we say that maslaha is the ontological concept, or should we say that it is utilitarian concept? Now, let me give you this example, a very famous example in comparative legal philosophy. It's called the Trolley Dilemma. Now, if one of you, my friends, let us say Dr. Al-Hanif, okay? Now, you are sitting in this part, if you see my the mouse, or standing in this part, and there is a train coming, yeah? One person is standing on one part of the rail, and 5 persons is standing on the other part of the rail. Would you, as a Muslim, what would you say Islamic law would do? Would the Islamic law tell you to kill the 5 persons, to leave, to stand like this and don't touch the switch and kill 5 persons, or divert the train to kill that 1 person? Now, this is a very, very fine and delicate question. It's called dilemma, the trolley dilemma. Now, let us read what Islamic legal philosophy would tell us in this situation. Should we do the act that kills 1 person, save 5, or not? Some of you might say that, well, it's very clear. We should kill 1 person to save 5. And I tell you, my friends, this is not exactly how we should understand maslaha. We'll only do this if we explain maslaha in utilitarian sense, as Jeremy Bentham, the English philosopher, would do. But if we use the ontological philosophy, why would we sacrifice that life to save the 5? This person, this 1 person, has sacred life as well. Now, remember here, my friends, that you are diverting the train. The train is coming to kill 5 in the first place, and your reasoning says that we should kill 1 person. But Deontology would say, no, that person has sacred life. You should let the train do its work. Now, the answer to this question in the Islamic worldview is vague. Maslaha doesn't tell us what should we do. Al-Ghazali, for example, will tell you, don't touch the switch. Abu Hamid al-Ghazali, he would tell you, just keep it. But if you go, for example, to Ash-Shatibi, Imam Ash-Shatibi from the 14th century, he would say that we should understand maslaha in maximizing the welfare of the majority, 5%, not just one. So how should we understand it? Classic Islamic, I know that I'm taking probably more time, but I promise I'll be finishing very soon. Classic Islamic discourse says, well, probably we should focus on utilitarian concepts. They didn't say this term specifically, but for example, Fakhruddin al-Razi, he said that how should we understand maslaha? We should understand maslaha as manfa'a. Manfa'a meaning interest. And how should we define manfa'a itself? Manfa'a is ladha. Ladha means pleasure. And pleasure should be maximized. This is, following the utilitarian concept. And then Muhammad Abu Zahra from the modern Islamic jurisprudence, he said that, well, we should, follow the utilitarian methodology in explaining maslaha. He specifically said madhab al-manfa'a. He said that maslaha in Islamic legal philosophy should be understood as utilitarianism. But as I found in my research, this is truly complex issue. And we cannot just say that maslaha is a form of utilitarianism, as many people say it. And I have several reasons I can share with you, but I don't want to waste a lot of time for focusing on the reason. I explained some of them in my paper titled Transformative Vision of Islamic Jurisprudence. And particularly those reasons will take a lot of time. But I will just focus on one concept from Abu Hamid al-Ghazali, or two concepts. Sorry. The Quran, in some areas, promotes deontological vision, not utilitarian vision. I give you specific example from the Quran. The Quran, in relation to slavery, says that slavery should be reduced. Now, in the 7th century, there were several verses trying to free slaves. عِتْقُ رَقَبَةٍ mentioned in the Quran a few times. The Quran abolished the sources of slavery. They didn't abolish slavery itself, but certainly placed the abolishing of slavery as priority in the social reform agenda. Every time you read the Quran, you probably come across a verse that's saying that tahrir raqaba, free a slave. Now, why would the Quran do this? Again, this is the task of legal philosophy. Now, this concept, freedom from slavery, is the ontological concept. Why would we say that maslaha then is utilitarian when the Quran is trying to promote the ontological concept? Also, Imam al-Ghazali, the first scholar who spoke about maslaha specifically, understood maslaha in modern, to use modern terminology, deontological concepts. So, for example, in his book Al-Mustasfa, Purified in Legal Theory, he discusses torture. Can we torture a person to extract information? A utilitarian would say you can do this if this will promote the benefit of the majority of society. Al-Ghazali said, no, we can't do that. Because that thief, that person, has, dignity. And dignity is the ontological concept. So we can't torture a person. Also, when a boat is sinking, can we throw one passenger to save 10 passengers? A utilitarian would say, please do it, hurry, do it now. Al-Ghazali said, no, you can't throw that one person to save the majority, because that would be utilitarianism, and that one life is sacred. So you can't throw one life to save the majority. Now, Al-Ghazali is not the only scholar who talks about this. There are scholars who promote utilitarian vision and would say, okay, let us throw one passenger to save the rest. because as I mentioned, what we should do is vague under Islamic legal philosophy. Now, my conclusion, we should have this developed transformative vision on reading Maqasid al-Sharia, Islamic jurisprudence, and when we come to define the nature to use it in comparative terms, we should be careful about coining what should we prioritize. Should we prioritize the ontological vision of Islamic maslaha, of Islamic interests, or utilitarian vision? In my research, if some of you are interested, I write a lot about this. I say that the ontology should be placed first order principle, and utilitarianism should be used as second order principle, and I define each sphere of influence for both philosophical concepts. Now, without further wasting the time, I am happy if some of you have any questions, remarks about this. Once again, thank you very much for this opportunity. Really appreciate it, and I hope I didn't use much more time than I should have to. Thank you very much.
Thank you very much, Dr. Is. Unfortunately, we cannot give applause to you because we are in Zoom online. So, okay, very fascinating. It is like we see the very long history of the development of Islamic law and also in Islamic jurisprudence. Okay, I will not conclude, take conclusion. So I just want to give the floor for everyone. So I will read one question from Adi Nur Rahman. He is from University of Bayangkara, Jakarta. So he raised a question. I will read. When we talk about Maqasid Sharia, so it is always would be related to many Islamic scholars' opinions, such as Satibi's opinion, that Maqasid Sharia is to protect 5 principles of human life. So perhaps it is also similar with the concept of Hanafi school of law, al-Ismah bil Adamiyah. So human life, those are life, property, religion, intellectual property, and progeny. So the question is Maqasid Sharia only limited to protect these 5 elements, or developing these 5 elements is allowed? And the second one is, what are the limitations in determining a condition as a maslahah? So before you answer the question, so if everyone want to raise a question, please you can chat in the chat, text in the chat room, or you can also directly speak in this Zoom meeting. Please, Dr. Is, time is yours.
Thank you, Dr. Hani. That's a really good question. Very good question. Can we extend the 5 purposes? As my friend might know, those 5 objectives of Islamic law, or maqasid, mentioned by Al-Ghazali in 2 of his books, mainly Shifa al-Ghalil and Al-Mustasfa, the Purified of Legal Theory, stemming from earlier general discussion Al-Juwayni mentioned in his book Al-Burhan. Now, after that, for 5-6 centuries later, this is why I said it's a good question. Islamic jurisprudence, the discussion around maqasid, stuck in those 5 objectives. As far as I know, I read for Al-Juwayni, Abu Hamid Al-Ghazali, Al-Izz ibn Abd al-Salam, Al-Shatibi, Al-Tufi. Scholars focus on these 5 objectives. But can we expand? Of course we can. Modern Islamic jurisprudence, although limited, very limited in relation to maqasid, there is a collective call to add more to the maqasid. They say they are not 5, they are more. I give you an example. For example, Al-Tahir ibn Ashur, Mufti of Tunis, a very, very famous scholar in the Maghrib, he said that we should add Al-Hurriya, Hurriyat al-Aqidah, for example, as a maqsad of Islamic law, in addition to the 5. Imam Yusuf al-Qaradawi, a lot of people know Yusuf al-Qaradawi. he also said that we should add justice and human rights to the concept of maqasid. So there is a chance to open, and in some of my papers, I specifically call on adding more objectives for Islamic law, for Islamic legal philosophy, based on different reading. You know, I see in different places, and I talk about this in my presentation, about freedom. Why the Quran insists on freedom from slavery? Guys, we are not talking in the 21st century. You have to understand this. We are talking in the 7th century. The Roman Empire and the Persian Empire existed then, and they had philosophers. But even those philosophers, the majority of them, they were promoting slavery. Christianity and Judaism did not talk about rules in relation to slavery, rules about freedom of religion, but the Quran in the 7th century came to do this. We need to understand why. To answer my friend's question, I believe that, of course, we can add, if we read the Quran with open mind, if we read the Quran taking into consideration our new development, our society, we will find the hikmah, we will find the wisdom that we can use as maslaha and then as an objective of Islamic law. I hope this answers the question.
Okay, thank you very much, Dr. Eej. Is there any more question from participants, please? If not, then perhaps I will try to have a question. Yeah. So, according to your own opinion, it is not about the maqasid Sharia, but it is about the global phenomenon of Islamic law, wherein, as we know that perhaps in Tunisia, perhaps in Saudi Arabia, and in Turkey, and perhaps in Indonesia too, we have some, I don't want to call it as a progressive Islamic law, but it is a different kind of Islamic jurisprudence, where in Tunisia, for example, interreligious marriage is allowed, even though Tunisia is now is considered as an Islamic state, where in Indonesia we do not formally forbid interreligious marriage, but we have so many interreligious marriage. And in some other countries, for example, like in Turkey, if I'm not mistaken, also in Tunisia, polygamous marriage is prohibited. Well, here in Indonesia, polygamy is still there. We cannot amend it. Perhaps it will not be gonna be happen if we want to amend the marriage law where which allow polygamous marriage. Do you think, based on your opinion, in the global Muslim world, do we see maybe someday that we will have a very progressive, transformative Islamic law that perhaps consider more on human rights, maybe gender and also some minorities issues?
Yeah, thank you for this question, Brother Hanif. Now, first of all, I must say that I am not qualified to give fatwa to say that to say that polygamy should be banned or restricted, but I can provide a general normative response, kind of philosophical response. Now, specific issues around marriage, divorce, inheritance are considered in the Islamic legal philosophy as part of the positivist scheme, the positivist part. Let me tell you, the majority of Islamic scholars, jurists, and philosophers would tell you that we should not touch that positivist part. I tell you why. For example, if the Quran in relation to inheritance says that the man should take twice as much as the woman. Now, if you subscribe to the Islamic religion, because Islam is you can freely enter into the Islam. If you subscribe to the Islamic religion, you follow this metaphysical belief from my perspective, I believe that the state should not interfere in polygamous marriages. Shouldn't say that this should be prohibited or this should be allowed. It leaves this to the people themselves. Now, I give you a good example, my brother. In all Western countries, they prohibit polygamous marriage, aren't they? So they prohibit it. We know this, right? I lived in Australia for 11 years. I hope my wife doesn't hear me. Now, I can't marry another woman in Australia. Yeah? But here is the problem, my friend. You can go and have haram relation. You can go and have a girlfriend in addition to your wife. So in essence, this is polygamous marriage, right? Because you live in two houses, right? And a lot of Westerners do it. But here is the problem. If that woman, if a child comes from this extramarital relationship, she will have no rights to be named after his father. He will have the woman will have no contractual basis to claim any financial support. But in Islam, things are different. Islam understands the human nature that men perhaps want to marry more than other women, but put a safeguard to protect the rights of the second wife, the third wife, the fourth wife. The thing that we should keep in mind, because we need to have like empirical appreciation of the situation. How many, in this percentage-wise, how many Muslims would marry more than one woman? Very limited. I don't know any of my friends with more than one wife. But if this happens, we should have this in contractual basis. So my response to your question, I believe the state should stay away from people's bedrooms. People can sort out this according to their own preferences. The state should only intervene to protect legal rights and don't enforce a vision. Now, maqasid al-sharia, as I mentioned, you will not find a specific answer to this question, but you will find a general discussion. Scholars would read the Quran, how this will work. And I give you examples from the period of Umar al-Khattab. He came to restrict the implementation of text. Sayyidina Umar, for example, he sought to put a limit on mahr, on the money that the husband gives to the wife. And then another woman came and said that Allah Azza wa Jal said, puts no limit in this. How did you come with this? He backed off. He refused to implement qat'ul yad, the amputation of the hand in Am al-Maja'a, the age of hunger. He saw that there is a maslaha in not doing this. People were hungry and somebody stole something. Now, he said that we shouldn't implement the Quranic injunction in this situation because the maslaha, the maqsad of Allah is to cut, or the objective of the Quran is to cut the hand of the thief who steals without any need. But this person stole because he was hungry. Now, I hope this answers your question, but as I mentioned, we should leave this outside of the specific legislative instruments of modern state.
Thank you very much, Dr. Is. Before we continue to other questions, is it okay if there are some participants raised in Arabic, right? Question in Arabic?
Absolutely. Please
okay.
Go ahead.
Thank you very much. For those who want to raise a question in Arabic, please feel free to speak in this Zoom, because I cannot read when you if you read in the chat room, yeah. If you write in the chat room. Okay, I give another floor to participant, please. If you want to use Arabic, feel free. More question, please.
Okay, Pak Hanif.
Yeah, please.
All right. Thank you, guys, for the very informative presentation. It's very recent development about Islamic jurisprudence. I have a very practical question to you as about capital punishment, because we now in Indonesia still have this capital punishment, even we executed some people. So can you please explain a bit about the recent development in Islamic jurisprudence, views about capital punishment? That's a very practical question.
Yeah, I understand.
Yeah, thank you. Yeah.
Myself, I am not specialized in Islamic criminal law, but in my readings about the promotion of life as one of the objectives of Islamic law, I sometimes come across discussions about executions. For example, hadd al-ridda. Some people talk about when a person comes and embraces Islam, they cannot exit. And some jurists say that if they try to repent, if they try to leave Islam, they should be executed. And so they use anecdotal evidence, isolated. This is why I sometimes criticize the positivist view of Islamic jurisprudence. They use singular hadith. Those who specialize in Islamic jurisprudence and usul would know, khabar al-ahad, it's called. To say that, look, the Prophet said that if somebody comes into Islam, we should, according to Islamic criminal law, we should kill them. We should execute them. Now there is a growing body of research and a growing body of legal opinions as well, saying that capital punishment here is not acceptable. Now they say that, okay, now you are telling us that the Prophet said that we should kill them. Did the Prophet do that? Did the Sahaba do that? We don't have evidence from Sirat ibn Hisham, for example, or from Tariq al-Tabari, those who spoke about that period of Islamic society. We don't have specific examples where somebody killed by the Prophet because they left Islam. Now, some might say that there is hurub al-ridda. Abu Bakr as-Siddiq fought those who decided to leave Islam because Arab tribes decided that they don't want to embrace Islam after the Prophet died. But I tell you that the main reason that scholars use for this is zakat, tax, not a matter of theology, because a person can do it in the comfort of his home. Sayyidina Abu Bakr as-Siddiq radiyallahu anhu in Arabic says that لو منعوني عقال كانوا يعطونه لرسول الله صلى الله عليه وسلم لقاتلتهم عليه. If they, prevent me from taking, this is the meaning, what they were giving to Prophet, I will fight them. Now I'll ask you, Jade, wouldn't modern state put people in the jail for not paying taxes sometimes? They would. But my point here is that Islamic criminal law in this particular issue of hadd al-ridda is started to be debated. Some say, okay, you are using the Sunnah, let me use the Quran. The Quran says no compulsion in religion. لا إكراه في الدين قد تبين الرشد من الغي. Also, the Quran said in Surah Al-Kahf, من شاء فليؤمن ومن شاء فليكفر. Let those who want to disbelieve do so, and let those who want to believe do so. Now, why you tell me now that Islamic criminal law will kill people for this? As for abolishing capital punishment, this will be very difficult. General capital punishment in Islam, this will be very difficult and unacceptable according to Islamic law, and I believe also Islamic philosophy. because I believe capital punishment should be there. In society, there will be some cruel elements that jail will not heal. Yeah. So if, for example, we find those who come in, do house invasion, for example, you are sleeping in your house, somebody jumps in your house, kills a family, robs them, or you are traveling across, countryside, somebody comes to take your property and kill you. Do you think that we should let them live in a jail cell for the rest of their life, feed them, and probably they will get some mercy and come out? The Islam in the capital punishment is not showing that the deen, the religion, is cruel. But in my opinion, the punishment, the capital punishment in the Quran is coming as a treatment for the cruel soul that will do heinous acts of killing to protect the society from it. I hope this answers your question, my friend Jade.
Thank you very much, Dr. Eid. Is there any more questions, please? You can use Arabic or English, or perhaps Bahasa Indonesia if you want, and then try to translate it.
I have my son, he's learning the Indonesian numbers. He's very happy about them. Because he studied grade 1 in Australia, and there they teach them Indonesian. So yeah, so he took the elective. I told him to take the elective Indonesian studies. So he learned the numbers. And I can't do that myself.
Okay, good to know. Okay, everyone, if you want to raise a question, you can use English or Arabic or perhaps Bahasa Indonesia, and I will try to translate it. Please. If no more question, then do we still have more time?
I think Bu Ainul want to raise a question.
Okay. Bu Ainul, please.
Karena saya terlalu pinter bahasa Inggris, saya pakai bahasa Indonesia, Pak Hansi.
Okay. I will try to help you. Yes.
Assalamualaikum, Mr. Izudin. Kalau di sini namanya Izudin, tapi sana namanya Izudin. Oke. Saya ingin bertanya, beberapa kali saya membaca berkaitan dengan riset-riset yang ada di luar negeri berkaitan dengan perceraian di negara-negara Islam. Apakah di sana cenderung tinggi perceraiannya? Karena beberapa negara Islam seperti di Indonesia, di India yang ada daerah-daerah yang Muslim itu terkenal dengan perceraian yang tinggi. Saya ingin bertanya kepada Mr. Izudin, saya sebut Izudin, Islamic name in Indonesia become Izudin.
Izudin, that's right.
Apakah di sana juga terjadi perceraian yang tinggi seperti yang di negara-negara Islam lainnya? Walaupun banyak diterapkan poligami seperti di Arab, seperti di negara Islam lainnya. Nomor satu, Pak. Ya. Nomor dua, ketika penerapan proses perceraian itu, kalau di Indonesia itu sangat menghormati pihak perempuan, pihak istrinya. Bagaimana kalau di sana? Karena penerapan juga di sini maqasid al-syariah juga diterapkan kan? Bagaimana kemanfaatan dari hukum Islam itu diterapkan ketika berproses di pengadilan agama di negara-negara Arab. Ini yang saya tidak ketahui. Beberapa tulisan saya ini macet di jalan karena memang belum mendapatkan jawaban berkaitan dengan ini. Mungkin ini membantu berkaitan dengan ada artikel saya yang setengah ya, tinggal ini yang ingin menguatkan. Terima kasih Bapak Izudin. Salam dari saya, Ainul Aziza.
Okay, thank you very much, Mbak Ainul. It is about divorce in Islamic law and in Islamic state and also in Islamic world. So is it considered as high if we compare divorce in Islamic state? Because perhaps due to the practice of polygamous marriage or perhaps some other else. So do you think that compared with other countries, divorce in Islamic world is considered high? And then the second one is that when recognizing divorce.
Brother Hanif, could you please repeat the first question?
Okay, the first question is that it is about divorce. If you compare with other countries, is divorce considered as high? I mean, the divorce practice is high in the Islamic world, in Islamic state, because perhaps due to the practice of polygamous marriage, perhaps. And then the second one is that when recognizing divorce, how about the rights of women or wife? Because in Indonesia, wife can propose divorce. They can divorce their husband. So
yes,
Mbak Ainul Aziza is writing an article about the divorce and also the right of gender. So please.
Thank you very much, Sister Ainul Aziza, for this question. Now, I don't have statistics from the Islamic world to tell us about the scale of divorce throughout the Islamic world. But I know that this is really high everywhere in the world, not particularly in Islamic countries. Now, we must understand that divorce is not driven by the injunction from the Quran, which gave the men the right to divorce the women. The main rationale, the main explanation for divorce, as we all know, is social problem, financial problem, household problem between the man and the woman. That would lead to divorce. Now, even the Catholic Church that prohibited divorce couldn't do so for quite some time, because the kings who were Catholics did divorce, and even Catholic devotees would do it. Now, religious prohibition against divorce will not work. The Quran permits divorce. Now, from my opinion, and I believe that this opinion is shared across Islamic jurisprudence, Allah understands fitrah, al-fitrah, human nature, that men and women will want an exit from the relationship. Now, why do you, some might ask, why would Allah give the man this right? Now, the man is the financially responsible for almost everything in the marriage, at least in that era. And in many cultures, many countries still is, for example, in my situation, and other people I know from different countries, men will handle all the financial expenses of the house. Men will handle preparing for marriage. Men will give money for the women to have the right of marriage. Now, because of this, I believe the Quran gave the men the right to divorce, because they were financially responsible to start the marriage in the first place. But the Quran also, and the Islamic jurisprudence and Islamic legal philosophy, I should say, gave to the women the right to exit from this relationship. I give you two examples. First of all, the Islamic jurisprudence made it okay, made it acceptable to give isma for the women, meaning that to give the women the right to divorce the man in the contract. Another example, the Quran gives the women the right to go to court and ask for divorce, to go to the Qadi Shar'i, a Muslim jurist, and will ask for divorce. And now this is a very prominent methodology for getting divorce in many Islamic countries. And I'm 100% sure that this is the case in Indonesia as well. A woman who, for example, being abused by the man can go to the court and ask that she wants divorce. Now, the state, you mentioned about comparison between Western and Islamic countries. Again, statistics should be available in special websites, and I don't think that there is a global statistic. I'm not sure. We need to look this up in Google to understand. I don't believe that there is like statistics, reliable, certified statistic from certain body to tell us how many Muslims resort to divorce. But I can tell you the number is high now and is growing because of the technological sophistication. Now, men neglect their responsibilities. Men do that more often because they have cars, they have internet, they have cell phones, they have smartphones. They could, do many wrong things, and divorce can come as a result. In the West as well, divorce is prominent. Do you know what people in the West do to avoid getting in divorce? They don't marry. They don't get into marital relationship in the first place, because the leading cause of divorce in the West is marriage. So this is why they stay outside of marital relationship, and when they marry, they don't marry from the West, because the women in the West, they started to abide or accept feminist methodologies, feminist philosophy. So, and the man will find himself without rights at the end. And we all know how this works in many Western countries.
Okay, thank you very much. Mbak Ainul, do you need the bahasa translation or not?
Kira-kira saya mengerti, Pak. Kira-kira, tapi saya pembahasa Inggris kan nggak mengerti. Pak, satu pertanyaan lagi, Pak. Ini menarik sekali, Mr. Isuden. Tapi bahasa Indonesia pertanyaan saya. Mohon maaf. Apakah terpengaruh dengan konsep patriarki di negara-negara Islam, terutama di negara Arab berkaitan dengan perceraian ini? Karena ini yang konsep kalau di Indonesia masih pengaruh, tapi tidak terlalu besar. Ada pengaruhnya, memang tidak terlalu besar. Perceraian itu memang dipengaruhi ada konsep patriarki. Kalau di negara Islam lainnya seperti di negara Qatar, di negara sana bagaimana? Apakah juga terpengaruh dengan konsep patriarki? Terima kasih.
Okay, it is still about divorce. The third question is still about divorce. So when considering divorce, is it related or maybe associated with the practice of patriarchal culture in maybe in the Arab world, or maybe in the, I don't want to call it as an Islamic world, because patriarchal is not Islamic. Please.
Yeah, definitely. And this is the right way to call it. And even the term is not patriarchy. We call it in Islam al-qawama. Al-qawama. Al-rijalu qawwamuna ala al-nisa means that the right to supervise. That's the qawama. And again, in the Islamic perception, or to use my own research, legal philosophy, there is a kind of deal, a kind of compromise. You are free to enter Islam. And from what I see it, and some jurists see it, you are free to exit Islam. Because my main vision of what will happen to a person exiting or leaving is metaphysical. Allah, I say, will decide how to deal with those who want to exit or those who want to stay. It's not for me to say that you deserve any kind of punishment, any person. Now, going back to the specific question, is it about patriarchy? Is it about, controlling the woman? When somebody exits, Allah imposes an obligation. It's not a free right for the man, by the way. The man doesn't have free right to divorce. It is, a right connected with obligation. The first obligation is to take care of the household, to spend on the household, to work hard. the woman is not required by any Islamic source to pay a dime for the man. The man is responsible. And for that reason, as part of the deal, Islam gives the man the right to supervise. Now, does Islam prohibit the women from getting divorced? Obviously, no. The Islam gives the woman the right to divorce. This means that the man cannot exercise arbitrarily the right to divorce. If they do this, they will have to suffer the financial consequences, and probably they will have to pay compensation for any damages. Islam doesn't say that they get this free of charge. So it's right tied with obligation. Now, I don't believe that this is a certification of patriarchy that existed in the Arab world, because the scope of patriarchy at that time was far beyond that. Women in the pre-Islamic period in the Arab world, they were like, sorry to say this, no offense to the ladies, they were treated with very low esteem. They were treated as goods. Men can marry unlimited women. They can do whatever they like. If somebody got a daughter, they can bury her under the sand. The Quran came to limit these evil practices, to abolish them, and to regulate, to organize the right of men to exercise certain privileges in the marriage. Now, Sister Aziza, we have together to understand something. When we talk about normative standards or rules of the Quran, we talk about 7th century. We are not talking about modern technological society. At that society, the man was the backbone almost of everything. So they were responsible for protecting the tribe. They were responsible for fighting, getting the food, getting the resources. And the women were responsible, mainly staying at home and cooking. Now, women had expanded rules. And I am 100% with increasing our understanding of women's rights in getting into the marriage and exiting from the marriage. It shouldn't be up to the man himself or herself, but as in any contract, both parties will have to respect the provisions of the contract.
Okay, thank you very much. That, I think, more than enough because the elaboration is beyond my knowledge, because as we perhaps most Indonesian believe that Arab world, when practicing Islam, means that some of us also will call them as practicing patriarchy, patriarchal norm from Islam, whether it is not. So it is about culture, a certain culture from a certain state. It is not based on Islamic law. So okay, is there any more questions before we give the time to Mas Bahrul?
There is a question, Pak Hanif, in the chat room.
Yeah, okay.
Yeah, from Mardani, and I think this is the new one from Grace Saran, I think.
Oh yeah, there are two questions from Mardani. What is the meaning of maslahah al-wulghah, and what is an example?
I didn't understand the question. Is it maslaha al-mursala, meaning, or maslaha al-mulghat?
Al-ulghah.
I would like to ask the questioner, because is it the cancelled maslaha? Does he or she mean maslaha, the cancelled maslaha?
Pak Mardani?
Or mursala, meaning unrestricted? Because the maslaha that we normally talk about is maslaha mursala.
marsalah mulgoh wa marsalah maslahah mursalah dan masalah mulgoh.
Maslahah mulghah.
Maslahah mursalah and maslahah mulghah.
Meaning that revealed maslahah. So we basically here use the classic jurisprudential methodology that there is a maslahah, interest that Allah, through the text, sought to protect at one point, or allowed at one point, and then the Quran came to reveal it through a naskh. I'm sure the questioner who asked the question understand the meaning of a naskh, meaning that one verse of the Quran reveals the other verse of the Quran. So I assume that he means by maslahah al-mulgha this sort of maslahah. And obviously there is an example where the Quran says about al-khamr, drinking alcohol. At some point, the Quran said that drinking wine has benefits, and didn't reveal it at that time, and then said drinking wine has benefits and has also harms. So at that time, it was acceptable that drinking wine was okay, allowed. And then the Quran came to prohibit it. So any maslahah that we see in drinking alcohol is revealed by the injunction from the Quran, which says that إنما الخمر والميسر والأنصاب والأزلام رجس من عمل الشيطان فاجتنبوه لعلكم تفلحون, meaning that drinking khamr is an aspect of the devil's work, and as a result, Muslims should avoid drinking alcohol. Okay. Now, this is my understanding of maslahah al-mulgha. I hope this answers the question.
Okay, and then the second one is from Grace, from Jakarta. There are 4 of us that, okay, wait a second. What is your opinion when maslahah against or cannot get along with Sharia? For example, there is a case in Indonesia about a decision from the Supreme Court of Indonesia regarding the inheritance of different religion.
Okay. Yeah, thank you for this question as well. Now, the maslahah I'm talking about is based in Sharia. I'm not talking about a maslahah that, I come up from my intellectual deliberation with myself or with other scholar. I am talking about a maslahah that we discovered through inductive survey from the Quran. We use istiqra. Istiqra is translated in logic as inductive survey. We read the Quran, and for example, we see what kinds of maslahah the Quran is trying to protect and promote in relation to inheritance. Yeah. So to answer your question, I don't accept personally, as a Muslim and as a writer, as a researcher as well, intellectual or reason-based maslahah coming from the intellect that contradicts with specific injunctions and specific ahkam from the Quran. But the question, maslahah and sharia, I believe they go together. The scholar Ibn Taymiyyah, in a beautiful phrase about your question, by the way, he says that maslahah is the sharia. Wherever there is the maslahah, there is the will of God. But he does not mean that the maslahah that a person will think that is maslahah. The maslahah, as I mentioned, that is informed by trying to understand or deduct or deduce hikmah from Sharia itself and from its main source, that is the Quran. Now, I hope this answered the first part. The second part, you mentioned that there is a ruling from the Supreme Court of Indonesia regarding inheritance of different religion. Now, I don't understand. If you could elaborate more, I might be able to answer. So do you mean that Indonesian court said that it is okay to give inheritance for other people from different religion? If this is your question, then okay, okay, Grace. Yeah, I mean, as I mentioned, the rules of inheritance, most of them specifically mentioned in the Quran, but not all of them. Not all of them. There are cases where the Quran is silent about certain scenarios of inheritance. And I gave you the example where as-Sahaba, the companions of the Prophet, right after the Prophet died, very quickly after the Prophet died, they faced the situation, inheritance situation. That's the al-wasiyya al-wajiba. The compulsory inheritance recommendation. They said, what would happen in this scenario according to the will of Allah? What is the maslahah? What is the interest here? Now, for those who don't understand this particular example, one person died before his father, and that person left kids. Now, in Islam, if somebody dies before his father, he doesn't get any shares in the inheritance when his father dies. And if he doesn't get, his children, the grandchildren of that person, will not get any shares. As-Sahaba came and said that this is unjust. They came and said, well, in this scenario, there is an obligation on the grandfather to allocate shares in the property for those grandchildren. Now, I am not expert in Islamic inheritance scholarship, yeah, but I don't see, or I did not come across any opinion or hadith from the Prophet which says that non-Muslims cannot get inheritance from Muslim in similar situation. So the non-Muslim wife, I didn't hear any specific opinion. As I mentioned, I will have to search if there is a fatwa or if there is an opinion, because inter-religious marriage were not common during the time of the Prophet or even the time of the companions. But again, we will have to go to maqasid. We will have to go to the objectives of Islamic law. Now, I will ask you, Grace, a question, and ask the same questions for those who understand Islamic law. Do you think that Allah will treat non-Muslim women unfairly and prevent her or prohibit her from getting inheritance when her husband dies? I add another question or remark. Allah allowed that non-Muslim woman to keep her religion even after the marriage, which means that Allah recognizes this woman as a wife. Do you think Allah is unfair, wal-'iyadhu billah, to prohibit non-Muslims from getting the shares from their parents? Well, I believe from my reading in the Quran, the Quran says everything about justice. The Quran says, وَأَنزَلْنَا الْكِتَابَ لِيَقُومَ النَّاسُ بِالْقِسْطِ. We revealed this book so that people can act with justice. And I don't believe that it is justice to prohibit non-Muslims from getting inheritance from their Muslim parents, for example.
Thank you very much, Dr. Is. We are running out of time, but we still have 2 questions left. So I will read the question from Zainal Mutakin from Islamic State University of Surakarta. So this is what he said. I heard that in some Western countries, it is normal to have a pre-marriage contract. do you think the pre-marriage contract is good in terms of avoiding divorce? Well, divorce is the term of the marital relation. Yeah, is it also good in protecting women's wife rights when divorce is unavoidable?
Yeah, I am very pleased with all of these questions. Many of them really smart questions, and they certainly provide insight into my own research as well. Here's my answer, and I'm aware of the time frame. We will need to go back and see, does the Quran prevent people from putting any questions they like at any time of their marriage process? I believe the Quran does not. The Sunnah does not. Even more, the Prophet ﷺ says in authentic hadith, المؤمنون أو المسلمون عند شروطهم, meaning that Muslims are free to stipulate conditions, and they should abide by those conditions. Now, in terms of the maslaha, do we know for a fact? Now, I'm using reasoning with you. I want to understand what we know about this, but I don't think that the time is enough for this discussion. But do you think for sure, 100%, that pre-marriage contract will help us avoid divorce? We don't know. But let me tell you, if we know statistically that this is better, then probably my answer would be Islamic legal philosophy would support or encourage pre-marriage contract, and I tell you why. Because in Quran, in Islam in general, divorce is not seen as a good thing, because divorce will have harmful consequences for the family, for the kids in the family, and for the married man and women. The women will go outside, and this is a door for hardships. So I believe that Islam wants مساكنة. ومن آياته أن خلق لكم من أنفسكم أزواجا لتسكنوا إليها وجعل بينكم مودة ورحمة. One of his verses, one of his ayat, is the creation of two souls, and his will to create the sakina, the musakana, between those two souls. Now, the Quran, the Islam doesn't want men and women to divorce. He recognizes this as a matter of necessity sometimes, but doesn't encourage it. Doesn't encourage. This is why the Quran gives the man the right to use divorce only 3 times, limited. It's not a limited right. If you use it for the 3rd time, you can't get back your wife without the humiliation exercise of marrying another man. So the Quran doesn't want divorce. So to answer your question, I believe yes, if those prove to be effective in preventing divorce, I think Maqasid would encourage them, because Maqasid doesn't want Muslim families to separate.
Okay, thank you very much. This will be the last question from Samsul Fatoni. How to limit maslahah by avoiding mursalah in order to remain in the corridor of Islamic criminal law, for example, in the case of domestic violence?
How to limit maslahah by avoiding murasala? I didn't understand what murasala means. In order to remain in the corridor of Islamic criminal law, for example, in the case of domestic violence. What do you mean by avoiding murasala?
Pak Samsul Fatoni, are you there? Are you still with us?
Yes. Maslahah mursalah itu
you can explain it in bahasa Indonesia if you want, and then I will try.
Maslahah mursalah itu penyimpangan untuk kebaikan. Jadi kalau misalnya di tempat kita itu karena budaya paternalistik begitu ya, jadi misalnya lebih mengedepankan penghormatan terhadap suami, sehingga ketika ada kasus-kasus itu kan kemudian tidak dilaporkan untuk kebaikan, keutuhan keluarga.
Okay. Okay, I get the point.
Yeah.
So what he understand about maslahah mursalah is that it is the misleading practice, but in order to protect the bigger interest of the community. So how do you think about the case of domestic violence? Because when we, for example, in Muslim families, we have domestic violence and then we don't report it to protect the honor of the family. Is it kind of the maslahah mursalah or what?
I don't believe that it is maslahah to protect domestic violence. Again, we will have to go back to the Quran and read, does the Quran give an open-ended right, free right for the man to abuse his wife? Does the Prophet recommend to Muslims that they should beat their wife and abuse them? Is this a maslahah protected by the Quran? Obviously, we know the answer is no. Even in the very limited case where the Quran allowed the man to beat his wife, even in that very limited context, it is highly restricted. عظوهن وهجروهن في المضاجع mean advise your wife, don't just go and punish her in the head. Talk to your wife 1, 2, 10 times. اهجروهن في المضاجع, leave their bed, and then واضربوهن. اضربوهن, it doesn't mean domestic violence. It doesn't mean abuse, constant abuse. This is why the Quran said فإمساك بمعروف أو تسريح بإحسان, meaning that if you want to live with your wife, live with ma'ruf, meaning respect her, don't domestically abuse her, or you have the door of divorce. Now, to answer this specific question, again, I believe that Islamic law should promote the right of women not being abused. The Islam should stop those abusive men from abusing their wife. And if reporting is the right thing to do, why not? But here is the problem. Even in the West, reporting doesn't stop the issue of domestic violence. Do you know that in Australia, women killed, and there is a statistic about this, Jade probably would know about this, women killed by domestic violence more than all persons killed by terrorist acts in Australia every year. It's a very prevalent issue, Western issue with a lot of freedom, but women still get killed. The problem is tarbiyah, what we call in Arabic, meaning the upbringing and how society deals with this. It requires awareness. If this goes to the police, if this goes to the courts, straight away from the first instance, it will destroy the family, but it will not help. So the maslahah is to find a rational solution. Perhaps if the Quran doesn't give us specific answer to this question, the Quran says, وَاسْأَلُوا أَهْلَ الذِّكْرِ. أهل الذِّكْر in some translations, saying those who have knowledge. We go to the sociology department and ask them, what is the right thing to do to prevent domestic violence? Is the maslahah to always report, or is the maslahah to have some kind of reconciliation and to make things work? If it doesn't work, we go to the divorce, something that Allah allowed.
Okay, thank you very much. I think I don't need to give more explanation because your discussion, explanation already give us new insights on the Islamic law, the transformative vision of Islamic law. So this is the end of the discussion, and then I give the time to my colleague Muhammad Bahrul Ulum. Please, time is yours.
Thank you, Mr. Hanif, for handling this discussion. we will soon close this event, and we want to remind the participants to fill the attendance form. And if you have any further inquiries, regarding the certificate, you can just contact me or just sending WhatsApp in the flyer that it attached my phone number. Okay, because the presentation and the discussion has been ended, it is the end of our session, and we thank the presenter and moderator and all the participants to join this event. And we will back to you to the 5th International Public Lecture, and we will inform you and updates regarding the 5th International Public Lecture on Faculty of Law University Jumbo website, and we will distribute this information to the existing participants, current participants, and the past participants by emailing you in about 1 week before the events. On behalf of the committee, we once again thank you for joining this event, and Assalamualaikum warahmatullahi wabarakatuh.